Call this meeting of the Civilian Review Board to order. Good afternoon, everyone. Hopefully, everyone has had the opportunity to take a look at the minutes from the previous meeting. Does anyone have any edits or additions? If none, I'd entertain a motion to accept.
So moved.
Thank you. May I have a second? Thank you. All in favor, please raise your hands. All right, minutes approved. Now I'll turn it over to the Inspector General.
Well, I'll start off by saying good afternoon. So in your packet, there is our update that we did for the month of September. Just kind of goes over some of the complaints received. If there's any questions, I'd be willing to answer any questions that you, if you have any questions, I'd be willing to answer any of the questions that you have. This is just for the month of September, and it also tells you for the total month, for the total year of 2024, what our totals are also. And then I also would just like to make a notation that the next board meeting, which would be in November, we should be presenting our third quarterly report that will have some additional information in there.
Does anyone have any questions for the Inspector General? I have one quick question. When do we anticipate having the annual report from 2024, just so we can try to coordinate the board's report that goes to City Council?
We'll be working on that most likely, I will say, towards like December, but the annual report we most likely won't have completed probably to the end of January, simply because we'll be getting a lot of information from the year that we'll be putting into that. I would ask that if the board has any additional, one thing we know is since we're going to be coordinating the two reports, of course, that's if the board wants to do that, we're going to be reaching out in some of the things that are in the charter that requires the board to report out on. We will be reaching out to some of the entities that we're able to collect some of that additional information, and we'll be adding that to the report. And then if there's anything outside of what is required that the board wants to have in that report, if you just let Stephanie know, she'll be working to coordinate that to make sure that both reports are combined together to make sure that they have all the required information that is required, not just for us to report to the board, but whatever the board wants to report, going forward to City Council.
Okay, thank you. Mr. Tobias or Ms. Ross, do either of you anticipate that the board having its completed report in February would be acceptable?
Yeah, I don't think that that's a problem. I know traditionally, my time at the prosecutor's office when Chief Prosecutor Baker Marish prepared those annual reports, they often weren't published till the end of March. Just because you need enough time after the end of the year to be able to compile stats. Sometimes you're waiting for other departments to get you the information so that you can add it to the report. So I would say as long as it's submitted to City Council by the end of the first quarter, you're good to go.
Thank you. Any other questions? All right. So that moves us to September cases. We currently do not have anyone from that subcommittee present, so then we will turn it over to Pastor Nathan for Subcommittee 1.
Great. So this is case 2024-28. Complainant alleged that a CPD officer sexually assaulted her in an unoccupied home on November 27th, 2023. There were numerous inconsistencies in her story. Among the pieces of evidence weighing against her allegation was cell phone data from her phone indicating that she was in a bar all evening and not in that home. More compelling still was a recorded phone call between the complainant and her sister in which the complainant admitted making the whole story up. And so regarding this allegation of sexual assault, the Department of Inspector General recommended that the complaint against the officer be closed as unfounded, and we concur. The officer, one other bit of information was the officer had a witness placing him at a different place when the alleged assault occurred. So this is, so we moved, well, can I do all my motions at the end? Yeah. Okay, so this is case 765. The complainant alleged that an officer wrongfully profiled her son. Body-worn camera evidence and officer testimony revealed that the complainant's son fit the description of a suspect who was running away from the officers. There was a second allegation that the complainant alleged that the officer used excessive force on her son by taking him to the ground. The evidence indicated that the complainant's son was non-compliant when the officer asked him to show his hands. He then pulled away from the officer, and the result of which was the officer used a leg sweep, which was level 1 force within the guidelines. Complainant alleged that the officer drew a weapon at her son. The evidence indicated that the complainant's son was non-compliant when the officer asked him to. It's a really nice voice. I like that man. Who was speaking there? I want to hear more. He should be a preacher or something. He's got that voice. The complainant alleged that an officer drew his weapon at her son, and the body-worn camera doesn't show that the officer ever drew their weapons. Finally, the complainant alleged that the officer falsified charges for which her son was summoned to appear in court. There's no evidence that the officer falsified the charges of noncompliance. So regarding these 4 allegations, the DIG closed each one of these as or determined each one of these were unfounded. We concurred. Regarding case number 830, this case arose as the result of the complainant's 13-year-old daughter and her friend being arrested for allegedly criminally entering a daycare and stealing items from there. Apparently, these two 13-year-olds stole toys out of a daycare center and were later found on the street. The complainant alleged during the incident that the officer slammed his daughter against a police cruiser, that the officer threw the daughter's phone to the ground, and that his daughter was questioned by the officer after he told the officer not to question his daughter without her parents being present. In this case, the DIG found that there was no evidence that the officer slammed the complainant's daughter against the police vehicle. There was no evidence that the officer threw the complainant's daughter's phone to the ground. And there is no evidence that the officer questioned the complainant's daughter after the father advised the officers not to do so. So the DIG found regarding each of the 3 allegations that the allegations be closed as unfounded. We concurred with the DIG in this case. Case 836, this case arose from an allegation that a CPD officer almost sideswiped the complainant's car because the officer was looking at his laptop while driving. The complainant had a camera in his truck which clearly showed the officer looking at his computer, veering into the complainant's lane, then correcting his driving after the complainant honked his horn. The CPD officer then cut him off without signaling, violating CPD policy. And so the officer would have been found in violation of CPD policy, except that the officer's last day was July 1st, and this case was closed due to an administrative closure. We did have a question that we could discuss at some point about whether something can go into the officer's file when there's the officer leaves during an open investigation, because sometimes we'll have officers transferring to another district or another police force, or being rehired back to the Columbus Police after retirement, and whether during an open investigation we would have something placed in the officer's file. And so I don't know if it's now or after, Chairman, if we can make a recommendation that something be placed in the officer's file indicating that there was an open investigation in which the officer either resigned or retired during that investigation, so that that would continue to be on record as opposed to an administrative closure. In this case, reasonable people would say, well, this is not that serious. But if it was serious, and we had an issue involving an officer who retired or resigned during an open investigation, we would like to see that recorded. That's, I don't know where that squares with the collective bargaining agreement, what policy is, but yeah.
Yeah, we can get you some clarity, but there are certain levels of offenses that if an officer retires while there's still an open investigation, they retire in what's called bad standing, such that if they were to try to apply for a new job, that bad standing would still be on their HR record. Additionally, if they are retiring and are leaving the force in bad standing, receipt of like the gun that your service gun or your animal, like those things are also prohibited if you were to retire while you had an open investigation for a certain level of offenses. So I will see kind of what the spectrum is, so you understand that, and then provide some clarity.
That would be really helpful, because this case raised those issues of an officer retiring, in the midst of an open investigation.
And is there anything that would prevent us, given the time limits or recommendations, from making a recommendation that simply asks for a notation of the investigation and its result being included in that file, knowing that that can go up the chain of command can...
Sure. I don't know. I know that they will generally ask if there are any open investigations against a particular officer who is trying to resign. So there is that checks and balances there. But I will add that too.
Okay.
Piece of information I'll provide that.
So I think, Board Member Nathan, I think your subcommittee could still make a recommendation today, and absent any objection from the rest of the board.
And so do I do it now or after?
I think you can do it with the rest of your motions.
Okay. Then case number 876, an officer observed the complainant and his friend jaywalking. The officer tried to get them to stop. The friend stopped, but the complainant ran away. The officer caught him. After he fell to the ground, the complainant got up, and the officer then tackled the complainant. The complainant resisted being handcuffed, finally was subdued by the officer. The result was force was used, but it wasn't excessive. The DIG finding was that it was unfounded. However, the DIG added a charge that during the tackling of the complainant, the officer used profanity, and so regarding the use of profanity, the charge was sustained. We had asked the DIG a question about whether the use of force is acceptable concerning a minor misdemeanor. And what we were wondering is, in the case of a jaywalking charge, can you pursue a complainant, and then if the complainant is non-compliant and runs away, can we tackle them? Or if the officer sees the complainant littering, and then the officer says, hey, stop, we're going to ticket you, but the complainant runs away, or the alleged offender runs away, and can the officer use any force to stop a fleeing complainant who's observed committing a minor misdemeanor? And so the answer is,
Depends.
There was more stuff. Yeah.
You go, and I will fill in if I.
I'm gonna punt here and basically say it just depends on the totality of the circumstances. It's a very fact-specific analysis depending on the unique facts and circumstances of any particular situation. So, I mean, if you're saying, hey, I'm talking about the situation right here in front of me, I'd want to read through I haven't read through that case and looked at all the specific details of the case. So I'd want to more critically and carefully look through that before I gave any kind of legal opinion on it.
yeah, could you point me, in this case, there was an allegation of perhaps viewing a drug transaction?
It's on page number 4. It talks about when we interview the officers, part of their allegations is they observed the complainants participate in what they thought was a hand-to-hand drug transaction. And so when they went to investigate the complainants, that is what happened with the complainant walking away.
You know, there are situations that can escalate that start out as minor misdemeanors, but then if they're giving lawful commands and the person is not complying, there could be a failure to comply charge, which is at least I remember, a first-degree misdemeanor. There's fleeing, eluding charges, which are first-degree misdemeanors. So it could escalate quickly, which would then give them the ability to arrest somebody.
Arrest would serve as a precondition that would allow use of force. Now, so it has to be reasonable under the circumstances, but that is one of the things.
So just curious, let's say we had a clean case. I still don't see that language, but I'm going to have to, I'll trust you that it's there. I still don't see that language of the drug transaction. So if it was a clean case involving a jaywalking charge, and an officer said, "Hey, stop! We observed you jaywalking," and the complainant did not stop. There was nothing else other than the jaywalking. There's no suggestion that I observed you doing something, handing something to somebody else. And they took off. We could tackle them. Use force. And that's currently within guidelines?
Fleeing an arrest. And then, so if an individual is under arrest, so all of the things would have to happen in order.
Well, this is a
for the
minor
individual to be
misdemeanor.
under
I'm
arrest.
just asking.
Minor misdemeanor, doesn't have jail time, so likely not going to be arrested. Again, use of force is kind of analyzed under a spectrum. So there is a level 0 use of force, which is to make a command, hey, stop. That's considered a level 0 use of force. Would be reasonable under those circumstances. Tackling someone for fleeing a minor misdemeanor offense, likely not considered to be reasonable under the circumstances. However, there's no real bright line, right? So again, you're going to always have to review these with a totality of the circumstances
I'm just
type
asking
of
you this
analysis.
specific.
But for that specific type of case,
Yes.
likely, probably not, a court likely won't say that that is a reasonable use of force given the circumstances.
And are there guidelines in the
directives. So I think
directives that say you cannot use force in the case of a minor misdemeanor?
No.
Or is this up to the police discretion?
Mm-hmm.
So sometimes
there are
they-
guidelines that there is a use of force policy that says if you are using force as an officer, you should consider these 8 things. And part of it is what is the underlying offense? What are the circumstances surrounding your engagement with the individual? Those are things that the directives encourage and require the officers to consider before they are engaging in any use of force.
I'm just trying to get my head around why this is discretionary. in the case of a minor misdemeanor, why we say to the officer, or we even put officers in that position to try to make a judgment based on 8 factors or 6 factors or whatever, to use force in the case of somebody who's jaywalking or littering or something, like what the thought process is.
I mean, I can offer in my 26 years as being a prosecutor, no officer wants to use force. None. It becomes necessary as any particular stop moves forward, depending on what's happening in real time, and it's fluid, and they have to make these assessments in real time very quickly. I've seen over the course of my career many times where minor misdemeanor offenses have escalated to jailable offenses, such as a 4th-degree misdemeanor disorderly conduct, a criminal trespassing, a assault even, a failure to comply. I mean, there's lots
Well, there
of...
would be a failure to comply if the person ran.
Well, and not even a failure to comply for running, a failure to comply, like produce some identification, or I need you to, if they have reasonable suspicion to make the stop and they are investigating and they say, I need you to stand over here for a minute so that I can talk to this other person, and they're not standing where the officers asked them to stand for officer safety reasons, that could become a failure to comply. That could be an obstructing official business charge. So it's just, again, it's fluid. It depends on the totality of the facts and the circumstances. But you could stop somebody, reasonable suspicion, minor misdemeanor, and within a matter of 30 seconds, it could escalate to a situation where you've now given them a command and asked them to do something, they're not complying, and then they've now committed that offense, which is jailable.
I completely understand, the additional facts and totality of the circumstances in the way that you're describing it. I'm trying to present a clean case and ask.
No such thing.
Well, somebody runs away from, hey, stop. I saw you littering.
The analysis is usually reasonable suspicion. If they have reasonable suspicion to stop and investigate and somebody runs, they could chase them.
I don't know that you're going to see a policy that is dictated on an initial charge, just because they're going to want to give officers the flexibility to be able to be nimble in those types of situations that do escalate into something more than what it started off as. But you will also, for minor misdemeanors in particular, oftentimes there's discretion at the forefront. Officer doesn't have to cite someone for jaywalking. Officer doesn't have to cite someone for littering, and that's where you're going to get.
I was concerned reading a
exercising that
jaywalking
discretion.
case and seeing force used. I happen to know that I jaywalk. And I'm just surprised. I think that if we, as the public, 80% of people, 90% of people probably jaywalk on occasion. And so reading a case involving the use of force is something I don't think that most of the public would expect.
I think some of the other factors are, were they dispatched to a call or did they happen upon it themselves?
They happened upon it themselves.
Right, and then time of day, what area of town they're in, are they familiar with the person?
Yeah.
In, things of that nature. I mean,
Do they have a warrant,
Do they
a
have a
felony warrant
Yeah,
that's outstanding?
none of that was
and
present
fine?
in this case. That wasn't present in this case.
Right. Which is why you need those facts and you need the flexibility to be able to, I think, make an analysis based on the facts of a particular circumstance. I think your question was, why is there no rule that says for any minor misdemeanor offense there should be no use of force? I'm just trying to give some context around why an initial charge may not always be the most appropriate to use to make a determination about whether or not force can be used either later in the encounter with an individual.
Is there some sort of best practice in terms of what to do in this type of situation? I just want to get a sense. So somebody's jaywalking, they turn the sirens on and say, hey, you're jaywalking, and then they start running away. Is the idea that you're going to chase after them, tackle them? I'm just trying to get a sense of that.
Yeah, you're right. Same.
Because the notion here is that the use of force was reasonable. That it was the determination made by the DIG. And so I'm just trying to get a sense of that seems to be within
Sure.
the.
I think I don't know if she's been able to determine whether or not the drug transaction was actually happening and that was viewed. But I think it was probably more than just a jaywalk according to the facts as the IG is presenting them. If we are reducing this particular hypothetical to just a jaywalking incident, Tobias, you can chime in here. I don't know of best practices. What I do know is that the directives clearly delineate what an officer should be looking at prior to engaging in use of force. And the type of crime is specifically delineated as a factor that the officers should be using. In addition to that, use of force should be used if someone is actively resisting arrest or is putting the officer or someone else in danger. Right? That's when those higher level of uses of force would be deemed reasonable under the circumstances. So again, I think totality of the circumstances analysis would be it is a minor misdemeanor. If fleeing from a non-arresting type of situation has happened, I think the police can engage in a policy discussion around are they chasing folks for minor misdemeanors only, right? They have a no chase policy for certain crimes that are committed. So that could be a policy discussion that happens, and that could be a decision that they make.
Yeah, because the way I'm reading it, it reads as if they're identifying an individual, that they're talking about the time of day. They've been there for a period of time in a specific area where there are a high crime, high drug area, and so they then happen to see them jaywalk. And that was the reason they turned the sirens. Versus did they
observed a drug transaction
prior to the siren or going on?
Yeah.
Okay.
I mean, and we kind of talk about that a little bit because the allegation, a lot of times the jaywalking term that is being used comes from the allegation because that's what the complainant is alleging. They're stating that, hey, force was using and I was arrested for jaywalking. So we always put in the report what the allegation is because, again, that's what we're looking at. But the report talks a little bit more about what was observed in the body cam, and we observed the officers when they were pulling the person over. And then when we talked to the officers to be able to see what was the reason for pulling the people over, the officers share that they observed a drug transaction in a high crime area. So that was them initiating the stop to investigate the people, to investigate the two individuals, which is why we, again, looked at, CPD policy to see, in fact, what was the justification? Was there probable cause? Was it justified? Did it file within CPD's policies and procedures for the force that they used, especially with them telling the complainants to stop, and they did not. So it was not just the jaywalking. It was what they observed initially, which kind of gave them.
So, and so it's helpful. My reading of this, and again, I didn't have this case specifically, but my reading of this was the initial was seeing a pedestrian in the roadway violation. And so it wasn't the drug transaction piece. That seems like that kind of came on at some point that they witnessed this. And I think that would be helpful in terms of knowing the facts and circumstances of when that was observed, because at least the way I'm reading it, it seems like they were in that area. It's designated as a high crime, high drug area, and they then happened to see the jaywalking and the drug transaction piece. And so it would be helpful, and I think maybe helpful facts and circumstances to know when did they observe the alleged drug transaction, and then when did they decide to pursue action? Because at least the way it's listed here, it seems like they happened to be there already, but they came into contact specifically because of this pedestrian in the roadway violation.
It is in the report. It's on page 4 when the officers was interviewed, and the officer states that prior to the pedestrian in the roadway violation by the complainants, both parties, they observe the complainant and another party participate in a hand-to-hand exchange of narcotics in a high crime area. That's on page 4, it's the first paragraph. And what we also did is we appreciate any questions that we get from the board. So we did get this as a question, and so we did make sure not only to respond to the committee, but I did also request, and Stephanie can let me know if not, we did send it out to all committee members in case we wanted to make sure that if someone else had the same question, that they would see that we did respond. And we did put the page on there where the information can be observed just in case someone had, a board member had an additional question.
Well, thank you. Well, can I make a recommendation then for a policy review after, or?
Yeah, I would
We
do
can hold on. I mean,
motion.
Yeah.
do we need to move on this case?
Well, given what they're saying about, this idea that, or this fact that the officer shared prior to the pedestrian, he observed this. It does come really late in the report. That's why I think we were, the facts seem to be leaning in a really different direction until the very last sentence of the report. So,
And is that consistent with the body worn camera footage there? Was that they witnessed the alleged drug transaction, and I don't know, did they start communicating about it? And then, because I'm trying to understand, they saw the alleged drug transaction, and then they put on the sirens and go out, or did they wait until they crossed the street to go after? I'm just trying to understand that sequence of events.
This is just my experience in doing defense work. I imagine that what they anticipated or thought was a drug transaction was observed. However, there's no other extenuating circumstances that would have given them probable cause to stop them at the time. So they followed them, and the moment they jaywalked is when they decided that they were going to pull them over for that sake, right? Because let's say they tried to arrest the young men beforehand or intercept them or pat them down. There may not have been reasonable articulable suspicion for them to conduct a search. It wasn't until they engaged in jaywalking that then is the reason that gave them the ability to make a stop. Does that at least sound closer to what I believe happened just reading the facts? I'm assuming, because my question is, were drugs actually found on these young men?
So what I kind of assumed something different, and I just got the text from my officers, and I mean from my investigators. So what happens a lot of times is what they observe is not always caught on body cam because they don't necessarily have to activate the body cam. So the body cam did not discuss that. It wasn't until they initiated their lights to stop the person, then your body cam comes on. And then sometimes it does capture, I can't remember how many seconds prior. That they'll sometimes capture that. It did not. So when we got the complaint, one of the things is to bring the officers in because you see what's on body cam, and I think what they were describing in the report is what they observed on body cam. It wasn't until we interviewed the officers to get more clarification as to what was the reason for the stop, and this is what they were saying, this is the reason for the stop, and they shared that with us, and that is in the report. And again, we try to make sure our reports are clear, but we will take note that this was something that we put in the end, and it probably just didn't provide.
and just to be clear about the facts,
If
I'm
I
sorry,
could real quick,
please.
though, do we know if drugs were found on the young men?
That I don't know.
We don't know, or there weren't drugs.
I would have to,
That's the question. Wait for them to respond.
oh, that we don't know. We would probably have to, he asked a question, we can actually, it might take a few minutes, and that's pulling the reports because we have a lot of document. So
Okay.
if he was arrested, we can probably pull the reports to see if in fact they did find some drugs on him.
Okay.
And then one thing here too, I mean, there was no interview with the complainant. There was a review of the voicemails. Is that my understanding as well in this, that the complainant wasn't interviewed?
I'm going to look to see. We always try to interview the complainant. Sometimes the complainants don't always return the phone call, but I'm just looking to see.
And
Oh,
the
you know.
supervisor said that the police report did show that drugs were found on the individual.
Which is not a requirement.
Yeah, it's not, yeah.
We need to make the stop, but it's helpful to know.
Yeah, the reason we were so focused on the jaywalk, just to be clear about the facts of this case, was not simply because that's what the complainant said and he framed the case. It was because one of the officers said that's the reason he stopped him. And that's on page 3. So he said,
Yeah.
one of the officers framed the case as a jaywalking case, not just the complainant. The officer framed it that way. The other officer who tackled him said that it was a drug case, not a jaywalking case. So you didn't have two officers saying, yeah, we observed this drug transaction and that's why we went after the guy. It's one of the officers said we stopped him because of jaywalking. The other officer who tackled him said we saw a hand-to-hand exchange
Yeah,
when all of this came up.
Yeah, given those inconsistencies, I mean, when you run it, when investigators run into inconsistencies like that, what is the determination? Is that that's not necessarily dispositive, and that just because that was a little confused. Does it not matter one way or the other in this circumstance? But that piece was just something that was a little hard to follow in terms of jaywalking violation versus actually we saw a drug transaction.
If we could,
Thank-
I'm going to ask us to
Well,
hold
come over.
that conversation till our last hour,
Okay.
just because that delves outside of this, that gets more into a broader policy question. I think if your committee wants to make an additional recommendation
We
of
can.
some sort, you can.
We will.
But I think we can have a broader question. I mean, I feel like I know what was happening after reading that, but
Great.
that's different than
Okay.
necessarily what we should see happen in other jaywalking
Yes.
circumstances.
Yeah, and that's what I'm trying to, yeah, I'm more concerned about that. You know, we do, have evidence that at least the officer who did the tackling said that he saw the drug transaction, and that's what we have, so.
And I did have a question on that. I mean, let's say they saw the drug transaction and a broader conversation about chase, no chase policy. I mean, is there a certain level at which that leads to, okay, if somebody's running, chase after them or not? I'm just trying to get a sense of that.
I don't know that I don't think there's a hard line. I think the flexibility is there such that officers can examine a situation. I don't know how familiar these officers were with that area, but they were familiar enough to know that it was a high crime area. Officers saw a drug transaction. Generally, the courts will allow officers to presume that it is an unsafe situation if drugs are involved. And certain drugs, they've started to lean another way. But generally speaking, high crime area, high drug area, saw a drug transaction, jaywalk, so had enough from a reasonable suspicion perspective to at least make the stop, and then a flee, which officers can presume.
Well, we'll make a recommendation at the end. so.
In most of my cases, the jaywalking was totally irrelevant.
Yeah, not
Because
relevant at all.
the
They
motions
use that to
totally
establish that
irrelevant.
reasonable
The motion
suspicion.
to suppress was upheld
Yeah.
based on a hand-to-hand.
Right.
Which is what they had here. And icing on the cake, they found the drugs. I mean, you have high crime area, you have, I don't remember the time of day, but you had all the indicia. And you had two officers saying they saw a hand-to-hand. That's
No, you had one.
one officer saying hand-to-hand, and usually the judge will uphold the motion will vote for the state in this situation. Now, one of the officers saying that it was because of the jaywalking, he or she is probably saying that because they don't want to say hand-to-hand, maybe, I'm just guessing, I'm not going inside their heads, because that jaywalking is
easier to
clean,
clean.
so they can say that. That's it.
That is true, and I think we're all making presumptions here. I also think the evidentiary standard for allowing evidence into court is very different from what gives you reasonability from a use of force perspective. But you've got not just a minor misdemeanor offense. You've got a ton of things of which are very closely related to. I think the courts have come down very closely related to danger in a specific situation. So if you're talking about immediate threat and the ability to use force, those are the factors that you would want to consider. So.
Okay. I'm ready to move on to case.
Well,
Our committee would sustain the motion. We would concur regarding both the original allegation of unfounded and the sustained motion regarding the use of profanity. And then we'll have we'll make a policy recommendation later. On case 942, this case arose as a result of an allegation by the complainant, who is deaf, claiming that the CPD failed to provide her with an interpreter after she requested one during a domestic violence investigation. She also alleged that her daughter was forced to interpret, though she didn't want to. So we've come upon this on a few occasions. Our committee has. The investigation found that the reason that the responding officers did not contact an interpreter, or they did contact an interpreter but weren't able to reach a division contracted sign language interpreter for the complainant and didn't find an officer on duty who could translate. Second, that there was no evidence that substantiated the complainant's allegation that the officer forced the 15-year-old daughter to interpret. They were advised, they advised the DIG, that is, the responding officers did, they advised Columbus DIG that due to exigent circumstances, in this case, the exigent circumstances were pretty significant. That is, that the complainant had been strangled by her son's father. And so in that case, the officers made the decision, which we found to be a reasonable one, that the complainant's daughter was asked to interpret for the complainant, to which she agreed. So in, regarding allegation 1, that they requested an interpreter and were not given one, the officers tried to get an interpreter, but there was not one available who could translate. Therefore, the allegation was closed as exonerated. Allegation 2, that the officer forced the 15-year-old daughter to interpret. She was asked to interpret. There were exigent circumstances, so it was recommended that the allegation be closed as unfounded. We concurred. Finally, case 1023. This was another case that we've had involving a special duty officer arresting the complainant for shoplifting, and it's without a body-worn camera. Unfortunately, the complainant in this case did not cooperate with DIG after numerous attempts to contact him. This was a situation involving a arrest at a Walmart by special duty officers. So because of the lack of cooperation, the DIG closed this administratively, and we concur with that decision. So in cases number 2024, I'm just going to read the last numbers. In case number 28, 765, 830, 836, 876, 942, and 1023, I move to accept the DIG's findings in all of the cases, and then I'll make a separate motion regarding the additional charge of profanity in case number let's see, 876.
May I have a second, please? Thank you. Any other questions? All in favor, please raise your hands. Ayes have it. Thank you. And then
we'll
you have two
reserve-
recommendations.
So the recommendation, yes, I'd like to have a review by the chain of command for discussion about the use of force in cases of a minor misdemeanor, and how that will work, in cases of jaywalking or littering or that kind of thing where there's no observed drug transaction or other circumstances. My recommendation would be that this not be a totality of circumstances discussion or where I'm walking in what part of town, but rather a simple statement that if somebody doesn't comply, they're allowed to flee. So.
Is there any second?
Second.
Okay. All in favor, please raise your hands. Okay, motion carries. And you had, I believe, Board Member Nathan, was there another recommendation about the issue with discipline or open investigations
Yes.
when an officer is, retires or leaves the force?
And so in that case, we would want something placed in the officer's file. I don't know how that comports with the collective bargaining agreement or the level of offense alleged against the officer, but at least to have some clarity of what the current policy is, and then we can make a further recommendation if we were wanting to see any change. But at this point, I don't know what the policy is, so I don't have any recommendation for a
Okay.
change.
So we'll just wait until Attorney Ross comes back
Yeah.
to us with. All right, I'll make a note just so it doesn't fall off our radar.
Chair Nathan, are you looking for a policy discussion with regard to just use of force as it pertains to minor misdemeanors, or both use of force and the officer's chase policy?
Both would be helpful.
Yeah, I think both, yeah. Yeah, that's helpful. All right.
Okay, all right, thank you. I'll turn it over to Board Member Younger for your committee reports.
Okay. Case number 2024-0806. This is an allegation of police misconduct filed May 23rd, 2024. Complainant alleged that on May 21, 2024, his wife was pulled over. An officer snatched her out of the car. 2, the officer did not tell his wife why she was pulled over. The complainant also alleged when he arrived on the scene, the officer told him that he had a warrant. And 3, actually, there's 5 of them. 3, the officer threatened to slam him on the ground. 4, the officer detained him. And 5, the complainant alleged that the officers did not give their names or badge numbers. The IG investigation consisted of CAD, BWC, review of ECC, and then review of policies and procedures. As to allegation number 1, this involves review of BWC footage. The officer found, there was no evidence that the wife was, snatched out of the car at all, so this was unfounded, and this is per BWC footage. As to allegation number 2, why pulled over, this indicated that this was a traffic stop. They identified themselves. The complainant's wife was informed by the officer that she failed to stop when exiting the parking lot and entering into the traffic. And there was no evidence to substantiate this allegation, so this was unfounded. As to allegation number 3, there was no evidence on the BWC that there were threats or that he was slammed to the ground. During the officer's attempt to apply handcuffs, the officer did advise this complainant, because he eventually did come to the scene, not to resist. The complainant continued to resist. He looked at the officer, trying to look at the officer as he attempted to place the handcuffs on him. The reason why he was placing handcuffs is there was an active warrant out of Georgia for him. The officer did advise the complainant a second time not to resist. At that point, the complainant stopped resisting. Handcuffs were applied. At no time did the officer slam him on the ground or slam on the ground. He did advise him that if he didn't stop resisting, he would be placed on the ground. Let's see here. So in this case, number 3 was deemed to be exonerated. Number 4, as to the BWC footage, the complainant was detained. The officers did determine there was a warrant, but it was out of Georgia's, it was in Georgia, the state of Georgia's jurisdiction. And the investigation found evidence that the alleged incident occurred. He was notified of this warrant. Let's see, he was detained by CPD, but then since it was only out of Georgia's jurisdiction, he was released. Therefore, this is an exoneration as to number 4. And number 5, the BWC did show for both officers no evidence that the complainant or his wife asked them for their badge or their names, and this allegation is unfounded. Our committee reviewed it, and we do agree with the findings of the IG. Case number 2, 0012. This is an allegation of misconduct. Complainant alleged that a CPD officer came to his home in Grove City, banged on the door, and threatened him. The investigation consisted of an interview of the complainant and an interview with the officer and a review of the Ring camera footage and also review of policies. The investigation revealed the officer went to the complainant's home to address a personal matter. The officer knocked on the complainant's front door, then stepped down off the porch when the complainant opened the front door. The officer advised the complainant that he was aware that the complainant had been sending text messages to his wife, flirting with her, and attempting to sleep with her. The officer was off duty, not in uniform, did not make or display any affiliation as a CPD officer during the encounter. The officer's actions did not violate a CPD policy or procedure during this encounter. The officer did not at any time threaten the complainant during the interaction. Therefore, it is recommended that this be closed as unfounded. We reviewed this, and everything was on the Ring camera on the porch there, and we agree with the finding of the IG as to this particular case. Number 3, case number 0834. This is an allegation that the officer was rude to this particular complainant during his handling of a traffic crash incident in which she was involved. The evidence consisted of CAD, BWC, a telephone interview with the complainant, and an in-person interview with the officer. Regarding the allegation that the officer was rude, the investigation found that the officer was not rude in his interactions with the complainant and was not in violation of CPD policy. It is recommended that this be closed as unfounded. That's it.
And you concur?
We did concur, yes. The next one is case number 2024-0868. This was an allegation of misconduct. The complainant alleged that her phone was taken by the officer during her arrest. The complainant alleged that she never received a property slip from the officer and her cell phone was not returned to her. The evidence consisted of CAD, BWC of the focus officer and the scene officers, interview of complainant, and CPD policies. The investigation revealed that the officer responded to a dispatched run regarding a suspicious person with a knife. The officer arrived on the scene, provided assistance as the complainant was barricaded inside of her apartment. The officer reported holding the complainant's cell phone up to the door in efforts to get the complainant to voluntarily come outside. The officer explained once the complainant exited the apartment, she was handcuffed, and he placed the cell phone on the hood of the cruiser of the arresting officer, though his action was not visible on BWC due to the angle. The officer was last observed with the complainant's cell phone. Based on a preponderance of the evidence, the Columbus DIG determines that the officer's actions violated CPD policy and procedure. Therefore, it is recommended that this case be sustained. What she is alleging is that there was no property slip, and there wasn't, and the cell phone was not returned to her, which it was not, and this is true, and there is no evidence to the contrary. The cell phone was not in her property, not given to the arresting officer, and the BWC S2, where the phone was, does not show that part of it because of the camera angle. And then, based on a preponderance of the evidence, this is so, and so we agree with the IG on this particular case. Next case is 0915, and this is an allegation of misconduct by CPD officer. This stems from a traffic violation. The complainant alleged that the focus officer opened the complainant's vehicle door, removed him from the vehicle for no reason. Additionally, he states that the focus officer used excessive force on him. The investigation consisted of BWC footage, CVS footage, a review of the use of force report, review of municipal court documents, and a review of the directives. The investigation revealed that the officer did open the complainant's door and removed him from the vehicle. However, the officer removed him from the vehicle due to the fact that the complainant was operating the vehicle with no license, failed to comply with the officer when asked to get out of the vehicle. Therefore, the DIG recommends that this allegation be closed with a finding of unfounded, and found that the officer's actions were within policy and he had a valid reason to remove this complainant from the vehicle. As to allegation number 2, the focus officer used during the incident, the force that he used during the incident was within policy. The force was reasonable. Therefore, the DIG recommends that this also be closed as unfounded. We agree with the IG on this particular finding. And the last one is case number 0935. This is a misconduct allegation. The complainant alleged that during a community meeting, the involved officer made inappropriate and unprofessional comments. The investigation consisted of an interview with the complainant, an interview with the focus officer, and then the witnesses who were at this meeting, review of the letter of apology written by the officer, sent by this listed officer, and a review of the applicable policies. The investigation found evidence that substantiated the complainant's allegation, and the officer's actions did violate CPD policy and procedure. Therefore, the DIG recommends that this particular allegation be closed as sustained. So we did discuss this, and the officer did make a comment at a community meeting, and he immediately wrote a letter apologizing for his particular statement at this meeting. And one of the committee members indicated that he wrote this letter immediately after this, before it was even brought up, this was even brought up, and it sounds like he was truly sorry for doing this, but it sounds like, from reading this, it sounds like it just may have been something that just came out of his mouth, and it sounds like he was truly sorry. However, what he said was, we could see that it could be hurtful and an inappropriate statement, and something he should not have said. So we do agree with the Inspector General on this. Thank you. I'm finished.
Do you want to make motions on all of those?
At this time, we move to accept the findings of the Department of the Inspector General as to 2024 0806, 0812, 0834, 0868, 0915, 0935.
Is there a second? Second. Thank you. Any questions? All right, all in favor, please raise your hands. Okay, motion's carry. Thank you. All right, Board Member Strickland, turn it over to you.
Thank you. I'm going to start with the review of pending September cases. I'm going to start with case 561. This was a complaint with the City of Columbus on April 11, 2024, alleging misconduct by a Columbus police officer. The complainant alleged that she was pulled over for a traffic citation and the officer, quote, yanked her from her vehicle and put his hands on her for no reason. The investigation reviewed this incident, and pertaining to the allegation, a review of body-worn camera footage and statements given by the officers had cause to conduct the traffic stop based upon information received from detectives. The investigation found no evidence that substantiated the complainant's allegation that the officer yanked her from her vehicle. Therefore, it is recommended that this allegation be closed as unfounded. Additionally, a review of the officer's statement, the investigation found the officer did not introduce himself by rank and last name, did not identify himself as an officer of CPD, did not briefly explain they are being recorded, and did not ask if there was a justifiable reason for the violation resulting in the traffic stop prior to engaging with the driver and attempting to remove them from the vehicle. The officer did not provide any reason to deviate from policy during his interaction during the traffic stop, and his actions violate CPD policies and procedures. Therefore, it is recommended that this allegation be sustained against the officer. Agree with the recommendation of the DIG of unfounded in the first allegation and a DIG sustained allegation in the second allegation of a violation of policy and not introducing himself as an officer of CPD. That is case number 561. Open for any questions or discussions on that case. Hearing none, we're going to move to 592. This is a complaint alleging that the complainant was driving his truck containing hazardous material on Interstate I-71, and the officer pulled him over and ticketed him. The complainant alleges the CPD officer had no reason to stop him. The investigation reviewed, including the body-worn camera footage for the responding officer and City of Columbus ordinances. The complainant was stopped for transporting hazardous materials within Columbus city limits. The responding officer issued a citation and summons for the complainant to appear in court. The investigation found no evidence that substantiated the complainant's allegation. Therefore, it is recommended that the allegation be closed with a finding of unfounded. And then it goes into quite a bit of an analysis on the City of Columbus ordinance around hazardous materials and as to why they made that determination of unfounded. Agree with the recommendation of DIG for this in case number 592. Any questions? Great. Next, we have a complaint alleging misconduct by CPD officer via the hotline. The complainant alleged that an officer, quote, falsely impounded his car, end quote. The investigation consisted of an interview with a complainant and with the officer, a review of body-worn camera footage, and policy and procedures. The investigation revealed that the officer responded to a dispatched run regarding a suspicious person who had been sleeping in their car and dumping trash in the area. The officer arrived on scene, investigated the vehicle, and found no one inside the vehicle. The officer reported taking appropriated measures to determine the vehicle's distance from the curb, though this action was not visible on body-worn camera footage due to the angle. The officer is seen investigating the vehicle. The officer cited the vehicle for being parked too far from the curb and had the vehicle towed. The Department of Inspector General determined the officer's actions did not violate any CPD policy or procedure. Therefore, it is recommended this case be closed as unfounded. The only question or that comes up to this, and that just a more general question, is like the choice to tow the vehicle was made because the car was parked too far from the curb. Like that was the allegation here. That was the reason to get the vehicle towed. To me, it seems like the actual, there was a call about a suspicious person in a vehicle that had been there. I just wonder, like, if the car wasn't parked too far from the curb, is there another violation that an officer could have used to determine to make that decision? Because that's just what it seems like to me. It doesn't seem like the call was to tow the car because it was parked too far from the curb, but rather that there was an allegation of a suspicious person or vehicle in the area for some time. And I just was wondering if that just happened to be what the officer used, or if there are other violations or citations that could have happened in that case.
So when officers respond, they have discretion as to what, I will say, tools they have if they want to impound a car. And in this case, his reason for responding to the run is what we put in the report, and then interviewing him and finding out what his reasons were for towing. We found that his actions did not violate any CPD policy or procedure. So had his actions violated a policy or procedure, obviously we would have put that in the report and we would have noted that, but his actions for towing the vehicle did not violate any policy or procedure.
Okay. And I don't know, I'm just trying to get a sense in terms of, and that's helpful, just in terms of, I know there's a tremendous amount of discretion, right, in this case, but if there's I'm just trying to figure out here if this is like a practice that happens often or at times, and if that's something that leads, because ultimately led to a complaint here that somebody was. Sometimes when somebody is parked too far from the curb, they would get a citation or a ticket. Towing someone's vehicle seems maybe in isolation a little excessive, but again, that's kind of why I'm trying to ask, like, are there other reasons? It seems like, I believe, based on reading this, that there were, but I wonder why that wasn't then included in their reasoning. And maybe it doesn't have to be, but I'm just trying to think about, if we're thinking about policy, we're thinking about a review board process, somebody files a complaint here, and if they otherwise would have been able to be in that area within their rights to be, that's where it gives me a little bit of pause, but I just didn't know. I'm not sure.
I do remember watching the body cam on this one, and I'm trying to the area. It was not. In just trying to recall, I believe it was more of an industrial area, so it wasn't like it was parked at the curb in a neighborhood where you would normally have vehicles parked. It was more or less, I want to say, it looked like it was an industrial area where the vehicle was parked, and so that might have been one of the reasons it was towed.
If I were, wouldn't that also give even more, like, the parking away from the curb is typically, right, you don't want to be in the way of the traffic. You're in a secluded industrial area, and I'm supposed to, I don't know what those parking lines look like, if there are any over there. To me, if somebody is not allowed to be parking in a secluded industrial area, that's one thing, versus they're being pulled over, or they're being towed because they were parked too far from the curb. I just don't know. Are there different levels of what the?
We're not here to argue about the police decision.
No, I hear what you're saying.
Yeah.
The only thing I would say is, when we conduct our investigations, the investigations really more or less or focus on whether or not, we're not subjective, we don't use our, we just looked at, what the scenario is. We find out what the officer did, and did the officer's actions violate a policy or procedure? And interviewing the officer usually gives us additional information if, in fact, we're not able to see that on body cam, because body cam does not always cover everything, which is why we need to interview the officer. And in this case, the officer's actions did not violate any policy or procedure. And it is actually in the report. I mentioned that, and when I'm looking at the report on page 2, it does talk about the review of the body cam, arrived at the scene to a secluded industrial area in response to a dispatch run of a suspicious person. And so, the thing that we always keep in mind, too, is that, the officer was dispatched to that location. He wasn't just, he was dispatched there for a reason. And so he responded, and based on his response, he took the appropriate action that he felt he was able to take within the confines of, the laws, policies, and procedures.
I think that the towing directive allows for the towing of a vehicle if there's a parking infraction. It gives the
Right.
officer
I mean,
the
yeah, there's a lot
discretion
of-
to tow,
Right.
Yeah,
for sure.
I
And I
mean-
hear what you're saying, but again, I don't know that there are any factors to consider. Like
Yeah.
the difference between the use of force directive versus it's just the officer can tow a vehicle if there is a parking infraction. And so I think their bright line was officer towed the vehicle. I think you all can continue to have a discussion about whether or not there should be additional policies put in place to give officers additional guidance on when towing is more appropriate or less appropriate.
Yeah. Yeah, that would be helpful. I mean, I think that I agree. I understand that there's obviously a tremendous amount of discretion here, but reading this case, that's not why the vehicle was towed. It doesn't read to me that it was parked too far was why the vehicle was towed.
And I don't think there has to be a why.
I understand it,
parking
but
infraction,
if
you can get towed.
Yeah, but if you communicate, and if that's the way it works, then that let's have that conversation. But you're communicating that we are towing you because you were parked too far from the curb,
Correct.
not that you were, which you can do, right? But I'm wondering, could you also not say this was a secluded area, industrial area, you can't even park here whatsoever? I mean, I don't know.
I think you can.
Maybe
I think
so.
you can. That's where the discretion is.
Okay,
That's not for us to do.
Okay.
We have to say whether it was a violation or
Yeah.
not, and it wasn't. You
perfect.
know what I mean?
Yeah.
So that's a discussion the board can have, and you can have with CPD.
You probably said it. Did they interview the officer?
Yes, they did.
And could you repeat what he said?
He reported taking let me see here. He reported when he arrived on the scene, he observed the vehicle to have sheets covering all of the windows. He walked around and knocked on the doors to see if anyone was inside, but received no answer. He reported he had the vehicle towed due to the violation of being too far from the curb, and he measured the distance by using his foot, placing it between the vehicle and the curb. He stated that this could be observed on his body-worn camera footage. So I guess, like, I mean, one, it's not even clear that, I mean, is that too far from the curb? Is that, like, the measurements we use? The foot was...
That's a tactic officers are now using because they can't chalk, because chalking is considered a Fourth Amendment, I believe, violation. And so they use other tools to measure how far a car is away from the curb to make a determination about whether there's been a parking infraction.
And does it matter whether or not it was or was not too far from the curb in this instance?
It definitely matters.
He wasn't in violation of towing. He didn't violate that policy. So, and that's why he was able to get it towed, because he didn't violate the policy.
Well, if I mean...
If there's a question of
I have a
fact as
legitimate
to
question.
whether or not the car was actually violating a
Right.
parking infraction,
Yes.
I can't answer that. I presume
Look,
that based on the evidence that there was confirmation that there was a parking infraction.
We could play this game all day long. I mean, you
Yeah.
could do it for every single case you review. Why? There has to be some objective measure of evaluation here, because, right, you'll never know exactly why.
Right.
Get into an officer's head and understand why. There could be 62 different reasons why. It's just you have to objectively apply the behavior to the policy to determine if there's a violation or not.
And I understand that. I just think, to me, it seemed like there was another reason that they wanted this car to be towed, and then it happened to maybe be too far from the curb, and that was the reason. But the notion that it may or may not have been too far from the curb, it does not seem like that matters in this instance.
So the run was because of a suspicious vehicle, right?
A person sleeping in a car for months who was dumping trash in the area.
Right, so to your point, yeah, the officer probably said, if I get this vehicle out of the area, it's going to eliminate the other behavior, potentially eliminate the other behaviors as to why I got called out there. But he wouldn't be able to tow the vehicle unless there was some parking infraction. So yeah, it may have justified some other means, but you can't do it unless it's within policy.
Yeah, but I think there's a reason, for example, that they are not able to do the chalk, right? And
Well, those are two different, I mean, the chalk is for like hours, like you can't be in a certain spot for more than, I think it's 72 hours.
Yeah, the rule is you can't park in the same spot for more than 72 hours.
Right, so now they use the measurement
Right.
from the curb to see whether they've moved the vehicle or not.
Right.
got it. Okay. All right. That works. I think warrant.
I think your discussion, the discussion you want to have is what types of discretion, or is there an opportunity to limit the amount of discretion an officer might have to move forward with the towing of a vehicle when there is a parking infraction? Right now, there's parking infraction, officer can tow. Officer doesn't have to tow. There's a bright line there. But if you want to have a discussion about when an officer can tow based on the type of parking infraction, that's fair.
And again, respectfully, to your point, there's a lot of reasons why officers do things that are uncomfortable for folks to hear and to know about.
Yeah.
It's just uncomfortable. But the analysis is are they doing it legally,
Right.
right? So, yeah.
Okay.
I think Mr. Tobias just cleaned this all up when he said the call was for suspicious person. You have a car here that's got all the windows covered. There's trash that they're supposedly towing out. He's doing his job here, and he's got to have something legally here. So he's acting legally, and it seems to me like, and I know we have to look at each complainant's thing closely, but it seems like he did his job here.
Well, but people have rights as well, right? I mean,
Absolutely,
I think
but
it is important if maybe an unhoused individual, whoever this was in this instance, if you're going to tow their vehicle for parking too far, but it actually was about trying to get you out of that space. That's all. I understand that there's quite a bit of discretion, but that piece to me, it's also not even clear whether or not it was parked too far from the curb, right? So,
Well, I don't know that there's lack of clarity about that because BWC camera footage showed how far away it was parked. I think we as a board haven't seen the officer's foot or the distance between, but the investigators did. And so I think that's how they can determine that he didn't violate policy is because if, let's say, he wears a size 11 shoe and only half of his foot fit between the curb and the car, then I think the investigator could have said that was a violation of policy because the car clearly was not a foot away. So I think that's a distinction, is that BWC camera does demonstrate what the investigator says.
actually, I don't know if that's seen in that part of the body worn camera footage. Look, it is what it is, and to me, it doesn't seem like that part was even dispositive. I think there's quite a bit of discretion, but I do think I just wonder why that was the choice made in this instance. It's been towed, vehicle's been towed, and there are other means and processes by somebody to follow up on that beyond the Civilian Review Board. So very helpful in that case. No further. The recommendation was based on the preponderance of evidence. Department of Inspector General determined the actions did not violate CPD policy or procedure. Recommended the case be closed, unfounded. Case number 657. This was a case where complainant alleged that on April 29, 2024, neighborhood kids were playing outside with toy water guns when two officers approached them and made them pull the toy water guns out of their backpacks to determine if they were firearms. The complainant alleged the officers harassed the kids. In doing so, Department of Inspector General investigation consisted of a telephone interview with the complainant, review of BWC footage, review of computer-aided dispatch information, and review of applicable CPD policies and procedures. The investigation found no evidence to substantiate the complainant's allegation. Therefore, it is recommended the allegation be closed as unfounded. The analysis portion was quite detailed in terms of the interaction between the officer and the youth here in this situation, and it was determined that the body-worn camera footage showed both officers arriving at this apartment complex and approaching the two youths. The officers asked to check their backpacks, and both youths complied. The officers recognized the toy water gun in one backpack, returned the backpack to the youth, and left the scene. The interaction between the officers and the youths were less than 3 minutes. Investigation found no harassment was made by either officer towards either of the youths, and the officers responded appropriately for the type of call they were dispatched to. Therefore, the recommendation, the allegation be closed unfounded. The one piece here that I would add is just in situations where officers are interacting with juveniles in terms of what that interaction should be versus communicating to an adult present, like that was the one question I had just generally thinking about this process. But in terms of the actual engagement itself, it did not seem to rise the level of harassment. But I was just wondering if that came up in terms of how officers interact with youth versus an adult being present.
Submitted a question to our office?
No. So just generally in terms of how, just to put there in a policy discussion or policy conversation does not have to be answered today in terms of just how officers interact with young people versus engaging or a conversation with the adult present or not. And so that was not dispositive in this instance, but that was a note that I just want to make a note of for future policy conversation and discussion. Thank you. Any questions on that? Next, we have 676. This is the case where the area resident called the Emergency Communications Center to request assistance for a complainant as a stranded motorist due to her vehicle running out of gas. The complainant alleged she and her fiance were treated in a rude manner by the officer who responded to the call. Based on the review of the evidence regarding the allegation the officer engaged in misconduct that consisted of being rude to the complainant and her fiance, the investigation found the officer was not in violation of CPD policy. It is recommended the allegation against the officer be closed as unfounded. The investigation did not find evidence that sustained the complainant's allegation of misconduct. It goes into analysis here how initially the officer reviewed this situation as an investigative nature based on the questionable circumstances. However, he later determined that they were there for a valid reason in this situation when they were stranded. And as a result, the officer indicated that the interaction was cordial and ended on a positive note. And based on the preponderance of the evidence here, the investigation did not find anything to substantiate the complainant's allegation. This is a case of unfounded, and case number 676. Next, we have case 711. This is the complainant said May 5th, 2024, into the early morning hours, he and his family were assaulted at a local bar establishment, and the officer who responded took a report of the incident. The complainant said that on May 7th, he contacted the Columbus Police Records Unit to retrieve the incident report and was advised there was no report on file. The complainant alleged the officer did not file the incident report, and as a result, he cannot seek charges against the person who assaulted him. Pertaining to the allegation and a review of the email received from the Focus responding officers, Sergeant, the case summary report, and both responding officers were in training the day after the incident, on vacation after the training, and the incident report was completed and uploaded by the witness officer on May 12, 2024. The investigation found evidence that substantiated the complainant's allegation, and the alleged incident violated CPD policies and procedures. Therefore, it is recommended the case be closed with a finding of sustained for both special duty officers which responded and reported to the incident. And that was case number 711, I believe. Any questions? Case number 760. This is a complainant stemmed from the officers arriving on the scene of a burglary in progress, and the complainant was not involved in police activity. The complainant alleged the officer stated, quote, "Come do something about it," end quote, to him, and he felt it was disrespectful. Additionally, during the course of the Columbus Department Inspector General's review of the incident, the officers were observed using profanity directed toward the complainant. The investigation revealed that one of the Focus officers did use the phrase, quote, "Come do something about it," end quote, and the phrase was directed toward the complainant. The investigation into the use of, quote, "Come do something about it," end quote, was found to be rude or discourteous in its context to the complaint as alleged. Therefore, the Department Inspector General recommends the allegation in regards to the use of "come do something about it," end quote, be closed as sustained. Additionally, the investigation found both of the Focus officers did use profanity directed at the complainant, and the use of profanity is outside CPD policy. Therefore, Department Inspector General recommends the allegation regarding the use of profanity be closed as sustained in case number 760. Last case is case number 773. This is the complainant alleging that an officer, after finding out his daughter made only one of the middle school's cheerleading squads, came to the middle school gym and yelled, used profane language, and slapped a water bottle off the table so hard that it went flying across the gym. The Columbus Department Inspector General's investigation consisted of an interview with the complainant, interview with the witness to the incident, interview with the Focus officer, an interview with the middle school's athletic director, and a review of CPD policies and procedures. The investigation found evidence that the alleged incident did occur. However, the officer was not acting under the guise of a CPD officer, nor would these acts be deemed unbecoming conduct. At the time of the incident, the officer was acting as a father. The school's athletic director was aware of the incident, and it has been handled by the school. Therefore, it is recommended the investigation be closed with an administrative closure finding.
May I ask a question? The complainant is whom?
The complainant is the, let me clarify here. I'm trying to figure out the relation here. Do we know the specifics of the complainant's I think she's the coach, is that correct? One of the co-coaches of the cheerleading team? I think she's one of the coaches. Yes. That the complainant was one of the coaches, makes this allegation that someone comes in to the gym. So I don't know how many cases we've had of this type. And again, I mean, I think the language here was that this was not under the guise of a CPD officer. I don't know. I'm not sure what. I'm not sure enough in terms of policies of what occurs outside of the outside of your role as an officer. I mean, with that said, I think there are situations in which that might, from a perception issue, but that seems to be outside of the scope here in this case. Is that the determination for administrative closure? And I don't know if the others have thoughts on that.
So with this case, what we looked at is what the allegation was. The allegation came to us from the complainant alleging conduct unbecoming, and we looked at what conduct unbecoming is within CPD policy. The officer's actions responding, he was not, even though he is a CPD officer at the time when he responded regarding some of the, I want to say, was involved in a school activity in which his behavior when he was addressing the people amounted to the fact that the complaint came to us because he was a CPD officer. When the investigation was done, it was found that the information was already brought up to the school administrator as to the incident and what occurred, and the administrator said that they had already looked into it, and they were already handling in the confines of how you would handle dealing with any other parent that may be not happy with some of the decisions that are made involving different school activities. And so based on that, that was the reason why we just did an administrative closure, because we didn't feel it arise to conduct unbecoming, and because the school administration was already handling the incident that occurred. But whatever the board.
Inspector General, just to follow up with that for a moment, is there anything else in police policy that had the case arisen from a different complaint, that is, this person understood police policy better and said, well, actually it fits under this work rule, or this, in terms of representing the city, or unreasonable conduct, or something else, because you frequently will raise, like, profanity. They didn't raise the issue, but you're aware that there's a violation of, policy regarding profanity, and so you add the allegation. Are you saying, yes, it wasn't conduct unbecoming under their allegation, but we also find that there's nothing else here, and so we would not be inclined to add anything to this conduct because there's nothing in what the officer did that, was just poor representation of the city or a violation of some work rule or something else, so we were disinclined to add something. Is that what you're saying?
No, what we're saying, and so again, the board, whatever decision the board wants to make on this, the board has the opportunity, obviously, to do that. What we were saying is that what we looked at based on the allegation is that this was a father. Yes, he is a CPD officer, but he came there, his actions of what he did of slapping the bottle may not have been the most appropriate action to take, but he didn't take that under the guise of being a CPD officer. I don't know, am I not answering your question?
Yeah, so I guess I'm just asking, in certain instances, you, on your own initiative, decide to add allegations, right?
Right.
Because you're aware of what the complainant is not aware of. And so, complainants sometimes don't cite the appropriate, they might have an excessive force charge, but you say, oh, no, this is not excessive force, but it is something else. Or the common thing that we run into all the time is the profanity things. And so what I'm asking is a real simple question. In this instance, are you saying that there really is nothing else in police policies that this officer, that we would, charge this officer with? That there's no violations at all, that coming into a school, that there's this bright line between being a dad and being a police officer, and him slapping the thing, or, he acts in some way just really inappropriately, but that's not a violation of any policy. I'm asking just as a matter of, I just am curious. Is there anything that you would say, this is an additional problem? They did not cite the appropriate policy violation, but there is a policy violation here, and we're concerned about representation of the city, even in a non-official capacity. So I'm just trying to get a feel for, like, if we have this in the future, like how does that work? So that's what I'm asking.
Not to interrupt, but our group just had a case like that. For instance, misconduct or excessive use of force, which is what your office investigates. Well, here, this officer was not operating as a police officer. He was operating as a father. In my case here that I just read earlier, with the Ring camera, he went there as a husband.
Yeah.
And he didn't go
But that
there.
wasn't the reason that case was dismissed. That case was dismissed because he acted reasonably in the circumstance. There was nothing impolite. There was nothing uncivil. He conducted himself well. And so the case wasn't decided on husband versus police officer. It was decided on reasonable versus unreasonable. And so what I'm asking is, as a husband, like if he came to the door as a husband, irate, and just started to scream at the guy and say, I'm gonna knock your head off if you see my wife again. I mean, there are things that where the line is crossed, and it's not official versus not official.
I see what you're saying.
It's reasonable versus unreasonable behavior.
Yeah.
So
And I think, just to remind us, we have had cases where, I think back to the officer with the social media account, that was not
precisely.
within the line of duty, but it was found to be inappropriate. And my guess is that the hitting the Stanley Cup off the table, that outburst of anger, I would say, was seen just not to rise to the level of what
is that the idea?
is.
I presume, I think to educate the board, just so you understand, there are definitely rules of conduct that govern officers who are off duty. And so just because an officer is off duty does not mean that they have
That's what I would assume.
the ability to act in any sort of way.
Yes.
What I presume the IG did was, I know you hate this phrase, looked at the totality of the circumstances and determined that this particular instance, quite different from the social media instance whereby his actions did not rise to the level of a policy violation. But it does not mean that he would, had he done something more,
Precisely.
that the IG would not
Gotcha.
have sustained a finding of unbecoming conduct or whatever the appropriate work rule is that governs
Very
off-duty.
good. That's what I would assume is the case. That sounds like a reasonable rule. Would you be able to send us that rule so that? Yeah, I mean, I'm just curious. Yeah, I would love
Okay.
to see the rule and apply it to this
Yeah, I
case.
can I'll hold this case for next
I'm sorry.
discussion.
You have
I
it?
think we have been given it in previous, it's been emailed to us. So.
The links.
Yeah.
the monthly emails and the links.
Well, here, and thank you for that.
The directives are as well.
And that's helpful. I think the question though is like, I mean, there's a lot of directives. There's a lot of policies, and it's a question of not just does the policy exist. It's how would a particular policy be applied in this type of situation. I think board members wants to review that and take a look at it. I think that's a reasonable notion. I'm happy to hold this case for further discussion. Don't need to move forward on this at the moment.
I know that so I just want to make sure I'm clear. You want the policy regarding the directive that talks about rules of misconduct. Is that what you want to review?
The policy had to do
With off-duty officers.
You know,
Yeah.
somebody who's off-duty, and how would you weigh that? Are you weighing it under totality of, I mean, did you weigh, I'm just asking a simple question, did you weigh it and
Yeah.
just say, no, we looked at that policy and then we.
And regardless, I would have, my recommendation here would have been to, regardless administrative closure, to actually forward this along to CPD for review,
Yeah.
Given this circumstances, even though if it was off duty.
Yeah.
So that would be my recommendation moving forward. I can still do that, but I can also wait if folks want to wait. But
Well, if that's your
yeah,
recommendation, then not.
well, well, I mean, I would say in this particular incident, I would actually forward this case along instead of an administrative closure that maybe doesn't go to CP. I don't know. I would recommend further review of this situation of potential policy violations regarding off-duty conduct in this instance. That's my recommendation.
What would your evaluation be, though? Because I think you can recommend evaluation, but do you want something to change about
Look,
the policy?
this is ultimately this is up to CPD and the police chief. I mean, if this is a practice or if this is an incident that happens and they feel that there's no violation or there's no further action that needs to be taken, that
Sustain then. Because that's different, like asking for the policy to be reviewed versus recommending or moving for a different finding and then letting the chain of command do the same review is different than recommending a policy change and then asking chain of command to look at a recommendation for a policy change.
I'm actually talking about reviewing this specific case, and
Then you
they
would
make-
change the outcome. You would motion for it to be sustained.
Don't they also review cases in which we find things unfounded as well? Yeah, right? I mean, okay, how about I hold this case for the time being, and then we could maybe have a further discussion about this. But that's my recommendation in this case. So I'm going to hold that for next time.
Okay, are you going to make motions on?
I'll make the motions on the
remaining
rest of them
cases?
on a 561, 592, 598, 657, 676, 711, 760 to agree with the recommendations of the DIG on all those cases.
Okay, I have a second, please. Second. I'm all in favor. Please raise your hands. Okay, motion's carried. Thank you. We'll take a 10-minute break and then reconvene at 4 o'clock. taken note of a handful of issues for discussion just based on this meeting. First is, what is the process for inconsistencies in motivation or reasoning behind an officer's actions? That was asked by Board Member Strickland. Is there a broader conversation about a chase, no chase policy? There was, Board Member Strickland also brought up the interaction of officers with young people versus when an adult is present or not. I think we've actually made a prior recommendation about law enforcement, CPD's policy about policing with young people, and taking a look at whether there is sufficient adolescent development embedded into those processes. And then last, which we didn't make, but I think we're just waiting to get back, and I just held it so we don't lose it, is the potential recommendation for placement in an officer's file, but we're waiting to hear back on policy. Does anyone want to speak to or give further discussion to any of those questions? Board Member Strickland did have to leave at 4 o'clock, so he was not here, or would not be here for this discussion unless we held it for the next meeting. Okay. Next question, how many board members currently would be able to be present for our November meeting if it remains on the 5th of the month? You can show by showing of hands if you will be present. Okay. And then have we heard from Dr. Jones?
No
No.
one else
Okay.
has been. I haven't reached out to anybody.
Okay.
He normally works on voting day.
Yes.
He normally works, that's us.
Yep. Maybe if you can email them, if we can at least get one more commitment that we'll have another board member, then we will keep that date. Otherwise, please keep an eye out for emails from Ms. Brock for rescheduling. All right. Unless anyone has anything, I will note we did not hear from the FOP for contract updates. Ms. Ross, I'm assuming another month at some point.
We're still working on scheduling with our labor folks. We
Okay.
want to bring them, because they actually interpret
Okay.
the FOP contract, and I think it would be helpful to hear from them.
Perfect, thank you. I will note that there are at least 4 members who have applied to be and fill the vacancies on our board. I have followed up with the mayor's office. I'm awaiting a response back to hear about the status of those applications. So hopefully we will have a fully seated board soon. If no one has anything else, I would entertain a motion to adjourn.
I'd like to make a comment, if I could.
Sure.
Before that, not to hold us up here
No,
longer.
absolutely.
I would like to bring up to the board maybe some motivation or suggestion that we police ourselves better. When I was appointed to the board, I took it very seriously. I took my application very seriously, and I think we need to consider ourselves, our commitment here to the citizens of Columbus, the city, to the board, some respect, that we show up on time, that we come to our meetings, we're diligent about I know our committee especially, we do take these cases very seriously. We discuss them at length. In the phrase of the day, in the totality of the circumstances, we discuss everything in the totality of circumstances. But I think we need to make sure we're here on time for every meeting. And we also make sure we attend meetings. I know there's been some lack of attendance problems, and I think we need to police ourselves and address that at a time when we need a full membership of the board to discuss these cases. So I'd like to just encourage the board, our fellow members, that we police ourselves and maybe do some introspection or soul searching. If we can't keep that commitment, maybe we should step aside gracefully and allow a new member to come forward that could do that.
Thank you, Dr. Ford. Any other thoughts or any motion to adjourn?
Motion to adjourn.
Thank you. I was going to say, we can all continue to say. All right, and we do have a second. All in favor of adjourning, please raise your hands. All right, have a good evening, all.